Megha? Hi, this is Rahul Reddy. We are here live from Houston, Texas, from Radio New NPC. Every Tuesday, we bring in business immigration news. Emily, what do we have today?
So today we want to talk about Friday at 7 o'clock in the evening. We had a presidential proclamation issued requiring health insurance in order to obtain an immigrant visa. So we're going to talk about who actually is impacted by that and what you need to know. We also have talked quite a bit about delays that we're seeing in H4 and L2 EAD adjudications. But we're also seeing long processing times of OPT applications and EADs for those that are in adjustment of status filing the first time. So we want to talk about what options you have when you're subject to one of those delays. We're also, as we're getting, now we're past October 1st, we've seen a lot of the CAP cases that were filed in April are finally being approved. Sometimes a change of status from F1 student visa to H1B is getting denied. Although the petition is approved, the change of status portion is denied. So we want to talk about options for that situation. And we wanted to give a little bit of background information about the TN visa. For those that may qualify for it, it can be a really good option instead of an H1B or something like that. So we wanted to give some background information.
Emily, on the President Proclamation, what does it mean? That everybody who doesn't have a medical insurance will be turned outside the country? They won't be allowed to come inside the country? Or is it applicable to all the immigrants, non-immigrants, immigrants, or what exactly is this one?
Yeah, I think that's the thing you have to be aware of. When any kind of new rule is announced, they're going to use legal terminology in that rule. So we may be talking about immigrants and talking about all kinds of immigrants, anybody who's from another country, but the word immigrant actually is only applying to the immigrant visa, meaning those who are applying for a green card at the consulate outside the United States. So it doesn't apply to all temporary visa holders. It does not apply to H, L, B, E, O, P, R, the whole long list of non-immigrant temporary visas.
So only for those people who are going to get the green card immediately, those are the people who will be affected.
Correct.
Now, in those particular green card applications, there are two kinds of people. One are the people who are trying to come from outside the country to inside the country, and one are the people who are inside the United States who are applying for the green card. So which one is the one this is going to affect? Both kinds of people, or only one kind of people?
Yeah, this is specifically for those outside the country applying for the immigrant visa or the green card at the consulate through what we call consular processing. So the majority of employment-based immigrants, high-skilled immigrants, are typically already in the U.S. when they start their green card processing and will be filing adjustment of status to receive their green cards. So this proclamation does not apply for them, just those that are outside the U.S. So it's more relevant for family-based immigration, where we see a lot more consular processing applicants. But employment-based, I don't think it'll have that much of an impact.
So for those people who are trying to get into family and employment-based, maybe they should purchase the medical insurance before they come into the United States. But for most of our audiences who are actually employment-based immigration, this proclamation shouldn't affect it. Now, having said this, Emily, of course, there is another rule called public charge rule. That is a little bit different than the medical insurance, but do you think so that may be applicable? Because on October 15, the forms are getting changed.
Yeah, I mean, under the public charge rule, now the concept of determining whether someone's going to be a public charge will be done by USCIS at the time you're filing an extension of your visa status or a change of status. Also at the time you're applying for the visa at the consulate and when you're applying to coming into the U.S.
So that's applicable, the public charge is applicable. What's the difference? So for the medical insurance, it's only for the green card holders coming from outside the country and applying for the green card at the consulate. But when it comes to the public charge, it's applicable to all non-immigrants and all immigrant visas. So what is the difference between the public charge and the medical insurance?
Yeah, I mean, public charge doesn't only refer to medical financial issues. So the medical insurance is just to deal with, according to the proclamation, to reduce the burden on Americans' healthcare system. Public charge deals with all of the financial aspects. So is there anything that would cause you to go basically on welfare in the future, or have you been on welfare in the past? That is what they're looking for, public charge. So it's not just medical issues, it's looking overall. Housing, have you used housing assistance? Have you used the food stamps, the SNAP program? That's what they're getting at with public charge, not just medical.
But for the kind of audiences that we have, mostly employment-based immigration, do you think so? We see any of the problems that might occur?
Yeah, both with public charge and with this proclamation on the medical insurance, I think most high-skilled immigrants are not likely to be impacted. You already have a salary that's enough to support yourself and your household. You're not even eligible for these kind of public benefits anyways, so it's very unlikely that you would have received one in the past. And so I think it's not something that needs to be too
unless something that
about.
stands out very clear for you, that you have financially distressed. A lot of people have, oh, I have a loan on the mortgage. No, that's fine, it's not a problem. I have a lot of credit card balance. No, that's not a problem. That shouldn't affect it, because most of the audiences for the employment-based immigration, the salary is way higher. Otherwise, you wouldn't be even eligible to be in this country. So you should be fine. This both public charge and the medical insurance should not worry. And even if any of you guys don't have a medical insurance for a period of time, it would not affect your non-immigrant visa or immigrant visas at this point of time. Don't be panicked if you don't have a medical insurance. You should still be fine. It's only for the immigrants who are coming into the United States on a green card application directly. It does not applicable to your parents who are coming on visiting visas, or if you're coming on H1 into this country, it's not applicable. Emily, on the EAD delays, you said in your statement that the extensions, even initial EAD applications, are taking 8 months now. OPT EADs are not taking that much as comparatively. They're still taking about 5 to 6 months now in some cases. And H4 EADs are taking approximately 8 months right now. And you have the adjustment of status taking 8 months right now. And L2 EADs are taking 8 months. What's the solution?
Yeah, we've looked at all of these different types of EADs, and you're still limited in your options for how to speed this up. You're still limited to the basic expedite request process, where you call customer service and ask them to expedite, and no matter how good your reason is, they deny it. You are limited to going to your congressman and asking them to intervene, and they just reach out to USCIS to find out what the status is and try to get the case before an officer. But if the case has already been given to an officer, there's nothing they can do. It's still up to within the normal processing time. So really the only thing we've found that worked, and we've been doing this for H4 EADs and L2 EADs, is filing litigation. File a lawsuit seeking to ask the court to compel USCIS to finish these applications, because it's no longer a reasonable period of time. And so we've looked into this option for OPTs that are getting delayed. We know on the STEM extension for OPTs, you have that 180-day period where you can continue working, and that's usually enough time. But for that initial OPT, you just graduated, you've got a job offer lined up, and now you have to wait 5 months before you can start because of a simple processing delay. And for the 485, same thing. If if your spouse is not in a work visa status and you've applied for the green card, the 485, you're eligible for that EAD. The only requirement to get that EAD is a pending 485, yet why does it take 6 to 8 months to do that? So all of those time frames are completely unreasonable. We know in the past USCIS almost always approved EADs in 90 days. So why is it that 6 months should be reasonable? It's not reasonable. So we think litigation can be filed for all of these different types of EAD delays. Once we file the lawsuit, we group multiple people together to try to keep the costs down. Once we file, the government has 60 days to respond to our lawsuit to the court. Rather than doing that, they simply reach out to USCIS and try to get all of the EADs approved within that 60-day period. So by the time that deadline comes around, they can just ask us to dismiss the case. And it's been working really well.
Emily, you're telling the litigation. Is it costly to file the litigation? How does it work with your office?
Yeah, I mean, obviously I can't share, fees, on the internet, but it is a relatively less cost than most people think it is. When you think of hiring a lawyer to go and file a lawsuit, you think of thousands of dollars, tens of thousands of dollars. It's not like that because we're able to group multiple people together to really reduce the amount of work that has to go into the lawsuit. So it is it's expensive. I'm not going to say that it's
and the Ready and Even PC, what we do is that every 2 weeks we file approximately about 50 cases. So in that way, we group up the people together and file it to give a discount rate for you as compared to filing each individual cases. And I think so. We are the only law firm that is doing it as a group litigation every week. Such big number of applications filing. And on average, from the July month onwards, or even late June onwards, we are filing approximately an average of 50 cases every other week. Our next the litigation we're going to file is October 11th, but it's already filled up the quota. October 25th is open, and the next one is going to be 2 weeks afterwards. So if anybody wants to join, if your EAD is getting delayed, it may be a right choice for you. Now, for those people whose adjustment of status is pending, and if they are filing an EAD extensions, it may not be worth for them to join the litigation, because once the extension is pending for adjustment of status, EAD, they could work up to 180 days. Now, that provision is not there for H4 EAD. If the extension is pending, you cannot continue working once the EAD expires. And that provision is not there from the L2 EAD. You cannot work when the extension or initial application is pending. Now, in the case for the OPT, the initial application, if it takes a long time, you cannot work. You may think of joining the litigation. That's a better option. And if you're filing an adjustment of status EAD, it takes approximately 7 to 8 months. So you may want to join the litigation to get it adjudicated faster, especially in the initial filing.
Yeah, and don't wait, 5 or 6 months for the normal processing to finish before you consider litigation. You can start filing a lawsuit 30 days after you file your I-765 application. So keep that in mind, that you don't have to wait the 5 or 6 months and then litigate your case. So one of the other things we've started seeing with the H-1Bs that were filed in April, we get some requests for evidence, especially for F1 to H1, where they're asking about maybe unemployment time, maybe someone's exceeded the unemployment limit. A lot of questions about OPT at a second master's or CPT from day one. So in a lot of situations, the change of status from F1 to H1 gets denied due to failure to maintain F1 status. So what are the options once that happens, when the H-1B has been approved?
The H-1B is approved, but the change of status is denied. Especially we see day one CPT college universities that get these things done, and also some of the STEM extension people that didn't maintain the paperwork properly. Well, first thing is that they should make an appointment. If the H-1B has been approved, they should make an appointment and need to move out to get the stamping as soon as possible. That's the number one step that they need to do. The second thing is that since the H-1B has been approved without the I-94, they could contact their university and try to get them into, it's called data fixing. The reason why the person gets kicked out of the civic system is, Emily, when they see the H-1B approval, it automatically comes kicked out of the civic system because the H-1B is approved. But the system doesn't recognize that the change of status has not been approved. You may want to go back to your DSO and have them fix the data. It's called data fixing. Show them your H-1B approval without the I-94 and then tell them to fix the data. Any other options?
Yeah, and one thing I want to mention is we're even seeing a problem when the H-1B was filed requesting consular processing.
Yeah.
And the H-1B gets approved in consular processing because that's what's requested, and the SEVIS record gets terminated, because the H-1B got approved. Well, it wasn't a change of status. No one requested a change of status. That's where I think the bigger problem is, because a lot of times students don't even realize it. I had people last year that this happened to, where they had, planned to travel and come back in on their STEM OPT rather than the H1, and we're told at the port of entry, you're no longer in F1 status, your SEVIS is complete. And it was completely a glitch in the system because the change of status was not applied for, and so they should be allowed to continue F1 status beyond October 1st. So check with your school if you're in that situation where your H-1B requested consular processing and is approved. If you're planning on continuing your F1 status further, check with your school to make sure your SEVIS record is still active.
And in those people whose change of status has been denied, or the H-1B is approved without the I-94, we do recommend people to go to their home consulate. If you don't belong to Mexico or Canada, don't go to US consulates in Canada and Mexico, especially when your change of status has been denied. There are some technical reasons why you should not do. We strongly recommend against going to Canada or Mexico if you're not from that country. Emily, on the TN visas, who are eligible for TN visas?
So a TN is very similar to an H-1B in that it's for typical professional level type of positions, but it's only for Canadian and Mexican citizens. Now, it doesn't require the country of birth to be Canada or Mexico. If you are from another country and acquire Canadian citizenship, for example, you are eligible for the TN if you have a job offer in the US for a professional level activity. So the TN category has a list of particular occupations that qualify. It's very similar to the H-1B in that they're typically occupations that require a bachelor's degree, but they are very specific. And so for each occupation, it will state what education is required to qualify for the visa. So that's one way that it's a little bit different from an H-1B. The benefit of the TN is that there's no cap on it, so you don't have to worry about a lottery. They're always available. You can get it at any time. You can get up to 3-year TNs at any given time, and you can keep extending indefinitely. But the TN does not have dual intent. So we talk a lot about how the H-1B and the L visa allows you to be in your temporary non-immigrant work visa status while also pursuing a green card. The TN does not have that option. So every time you're extending, every time you travel, you need to demonstrate to the officer that you are not an intending immigrant, that you only have a temporary intention at that time. So that is one thing to consider between, if you have the option of an H-1B versus the TN, is do you plan on sponsoring the green card? Another benefit of the TN, especially for Canadians, is you do not have to file with USCIS. You can actually take your application straight to the port of entry and apply at the border to come in. For Mexican citizens, you don't have to apply with USCIS, but you do need to get a visa stamped by visiting a consulate before you can come in. And those visa stamps are only given for 1 year instead of the typical 3 years. So a few things, a little bit differences here and there, but it can be a good option for a Canadian or Mexican citizen.
And you said that people who are actually not born as a Canadian nationals, they are actually immigrated into Canada, and now they are Canadian citizens, so they can come under the TN visa too.
Yep.
What about the green card holders, so permanent residents of the Canadians?
Yeah, that's it's not allowed for green card holders in Canada for Canadian permanent residents. It's only, you have to be a citizen there.
Okay. Let's go to the questions live on YouTube and Facebook. I'm getting a lot of questions on the S386 and also HR 1044. Is there any activity going on? Until last week, there was a lot of activity. In the previous week, a lot of activity was going on. But starting from October 1st, because the year changes on October 1st, according to USCIS and also for the government, we haven't seen much floor activity at this point of time. Senator Durbin put a hold on this on the S386 bill, which probably could eliminate, for the most part, the per country limit. With some limitations, it will eliminate the per country limit, which would be good for for the backlog countries, and also eliminate the discrimination based on the national origin. However, Senator Durbin chose to put a hold on this one. If I'm not mistaken, a day after tomorrow there is a rally in Illinois, in Chicago, Illinois, in suburbs of Illinois, Chicago, at his office. If anybody wants to, that's one thing you may want to consider to rally on this one. But no floor activity that I've seen on the Senate 386 at 10:44 at this point of time. I want you guys, those people, please be effective on contacting the Senate. Don't just sign the White House petition and be satisfied you did some work and be happy and sleep. No, that doesn't help. Write a letter. Emily has drafted a letter for you guys at immigrationgirl.com. Please use that letter and please describe your personal conditions, what job you have, how many kids you have, do you have a house, where do you live, what do you contribute, what is your job, what is your salary. Describe all those things and write a letter to the senator and then contact them. Just don't call those automatic number. Are you yes, are you no for this Senate 386? Don't keep on putting that thing. That's not going to help because we know there are some haters and there are racists that are calling and they will call, we hate certain race people, so don't give it to them. So they are the people who are going to call. They don't explain that in their letter clearly. You should explain it to the senator very clearly. A lot of people ask, oh, my senator is already favorable. My senator is not going to support this. Well, if your senator is not going to support it, well, that's what you need to put a pressure on. If your senator is already supporting it, you need to tell thanks to that senator for supporting. Senator Hill from Utah, I mean, you want to support that guy. He's the one who is doing all the, a lot of work for this one. You may want to write a letter to that guy. Thank you, Senator, for doing this one. I appreciate it. My family is this, my kids are going to school and what you're doing, we appreciate it. These senators will take a look into those things and don't just count those people who are already in. I mean, don't just ignore them. Thank you for what you're doing in an effort. Please, the senators that are opposed, contact them. Senators that are supporting, please contact them. Do contact the senator of your home, where you are located at. You don't have to be a U.S. senator, you don't have to be a U.S. citizen to contact your senator or congressman. Even thank you to the Congress people. They voted, about 82% of the people voted for this H.R. 1044 bill. And thank you for your congressman for voting for this one.
All right, I've seen a number of questions regarding what is considered to be under the public charge rule, what benefit is considered there. So I want to make it very clear that not everything that you might think of as a public benefit is considered an actual public benefit under the public charge rule. There's a very specific list. It is dealing with food stamps under the SNAP program. It is dealing with housing assistance from HUD. It is dealing with very specific categories. And actually, if you go to immigrationgirl.com, I have a post there about the public charge rule that gives you the exact wording of what's going to be on the new form for the I-129 and the I-539, which is supposed to come out next week, but it's still not available. So if it's not on that specific list, it's not considered under this public charge rule. They're very set things that can cause someone to be considered for the public charge. If it's not on that list, I don't think it's considered a public charge or considered a public benefit for purposes of that rule.
401k definitely is not a public charge. Even if your employer is, even if you're not contributing, your employer is contributing, that is not a public charge. Your employer is contributing, so it's not a public charge. Absolutely, I get that question from Facebook, from Jay.
Minal from Facebook wanted to know if the Nexus program allows Canadian permanent residents to travel back and forth into the U.S. Well, the Nexus program is not a visa, so you actually have to qualify for one of the different visas out there. So whether you're coming in on a B1 or B2 or H1 or H4 or TN, so it's the visa that allows you to come into the U.S. The Nexus just allows it to be a little bit smoother entry process, just a different line to get into. So the Nexus itself doesn't provide you with a way to enter the U.S.
I have this question. I got this question a couple of times before, Emily. I need your attention on this question from Ajay from Facebook. What he's asking is that if you buy the insurance from the the Obama health insurance discounted plan for the kid who is a U.S. citizen, will that affect the public charge?
Well, for one, it doesn't apply to U.S. citizens, so it's your kid that is getting benefits there, not you personally. So it's only when it's you who's obtaining these for yourself, not for the benefit of someone else, and that is not one of the listed benefits of what they're trying to avoid. They are very specific, so if it's not on the list, it is not considered.
One question that came from the YouTube is that my H-1B is approved and my spouse H4 plus EAD is pending. If I travel, will it affect the H4 plus EAD? No, you're good. Absolutely no problem with it. You can travel.
Suhail from Facebook has the renewal of his EAD based on adjustment of status pending and wants to know if it's okay to change employers while you're using that 180-day automatic extension. So when you file a 485 and you file an EAD along with it, then you're renewing that EAD. You do get 180 days of automatic extension while you're waiting for the new EAD to come in, and there's no restrictions on not changing employers during that time. So yes, you can change employers during that time. The receipt notice plus your expired EAD card is sufficient for you to fill out an I-9 with your new employer to document work authorization. Of course, if you are the main applicant of the 485, you need to make sure that you qualify for AC-21 to keep your green card process going if you fall into that category.
A question from Chetan from, well, he put a message in YouTube and Facebook both, is that if his EB-1A has been denied because of the significance criteria, he wants to now file under EB-1B. Is EB-1B easier? Well, if you are in the research program, if you probably have a PhD degree, and if your company is filing for your green card application and your company has at least 2 other researchers, obviously EB-1B is much easier compared to the EB-1A. EB-1A is extraordinary ability. EB-1B is outstanding researcher. Definitely it will be more easier. The standard is lower for EB-1B. As long as the EB-1B falls into the research, you should have a better chance of getting under EB-1 approval. Now, if it doesn't fall under the research, it may be, it may not qualify for under EB-1B. But EB-1A is a definitely much higher standard, and for EB-1A, you don't require an employer. For EB-1B, you must have an employer. The employer's qualifications becomes an essential part of your getting EB-1B. So if I have somebody eligible for EB-1B and EB-1A, I would always go for EB-1B if they're eligible for it because it's easier. And Chetan, you must have already known that for EB-1B, your employer has to sign the petition. You can't just file by yourself.
Suzette from Facebook wants to know if you can have an H-1B petition filed while you also have an H-4 and EAD application pending. So I get this a lot. There's nothing inherently wrong about having 2 different types of applications pending at the same time. You just have to be aware of the timing of the approvals of the application. So for example, if you have your H4 and EAD extension applications pending and it's going to take 6 months and you get your H-1B change of status approved in 2 weeks, and you want to be in H-1B status, you need to make sure that the H-4 gets withdrawn because 6 months from now you don't want to end up with an H-4 approval taking you out of H-1B status. So that's kind of the main thing to be aware of, is just the timing of the approval so you end up in the correct status that you want to be in. And also, whenever you're filing any kind of change of status, you always have to be in status at the time you're filing. So if, for example, you're in your situation, you just mentioned it's an H4 and H4 EAD application that's pending. We don't know what type. Was that a change of status? Was it an extension? Let's say it's an H4 extension that's pending and your last H4 already expired. Then, if you're filing an H-1B, you are not in H4 status anymore. You are in a period of authorized stay, and you're not eligible to now change status to something else because you don't have your new H4 approved yet. So those are the two things to consider if you've got multiple applications pending at once.
Anil has this question that he is about to get married, and what are the chances he has his I-140 approved? What are the chances for the H4 EAD for his wife to go through? At this point of time, I mean, people are worried about the litigation that is going on in Washington, D.C. You don't have to worry about it, the litigation, at least right now, because the litigation only deals whether or not the plaintiff has a standing. They haven't gone to the merits of the case. So it's going to be a long while before anything comes out of the litigation. As far as the regulations of scrapping the H4 EAD is concerned, at this point of time, they haven't released any proposals yet. They did indicate that they're going to release a proposal. They most probably are going to come in the in 2020, maybe in the early or middle part of the 2020. Now, just because they issue the proposed regulations, they don't become effective. There's a timeline that normally is given. So we're not expecting, I'm not expecting anything until about June to September of 2020, are you?
Yeah, I would agree with that.
Yeah, I mean, our guess may go wrong, but we're not expecting anything to be finally published until June to September of 2020 at this point of time. Now, a lot of people ask this question: what will happen to the existing EADs? What will happen to the pipeline EADs? What will happen to the future EADs? Based on our previous readings of how the administration have dealt with, they have never said, even the Trump administration never said, all the EADs, existing EADs are canceled. They never said it, because it's going to be a nightmare for them to implement how the EAD that is existing, they can say that it's not valid anymore, because it's going to be a nightmare for I-9. So we're not expecting that. Even the previous EADs, when they didn't allowed, they only said 3 months from now, 2 months from now, you may not be able to extend these things. And this H4 EADs came into existence through regulatory process, unlike most of the other EADs that he has canceled, which came through the executive order or some other sources. This came through the regulations. The last time when they actually wanted to give the H4 EADs, they took more than 1 year once the proposal for the H4 EAD came in. So we may be, the timeline that we said is the minimum timeline that we are speaking. We don't give the maximum timelines being in immigration lawyers. It may be for a long period of time. So we are expecting from June to September, until June or September, nothing is going to be finalized. And when it's going to be finalized, maximum time, we don't give it. And if there is going to be finalizing, the existing pipeline applications should still be adjudicated. Now, these are all our estimate. I've been in practice of immigration law for 25 years. These are all our estimates. We may be wrong, but this is our projection.
Srinivas from YouTube wants to know if the EAD approval is taking more than 90 days, if I already have the visa stamp and apply with my I-94 based on that instead of applying for the extension along with it. Yes, they are taking more than 90 days. Current processing time at each of the service centers can take up to 6.5 months for regular processing time, and of course there's no guarantee that they have to approve it within that 6.5 months. So even if you already have the visa stamp and are applying for the EAD by itself, the standalone EAD can take a long time still.
Emily, you worked as a teacher, so you might have a little bit idea on the school meal program. I thought that the school meal program has 2 ways that I pay money to my son and then he gets to eat in the school. Is that right? That's one way, which is not a public benefit at all. The other way is that I declare myself that I don't have money at all, and then I get a discount in the school. Is that right? Mm-hmm. Is there any other third way of getting a free meal in the school?
Not that I'm aware of.
So if you are, this question comes from Sai from YouTube, is that if you're paying the money and then your kid is eating in the school, we don't see anything problem. But if you disclosed that you don't have any money and your income is not there, and you're actually making an income which is more than what is there, we do see that there is a problem there. Do you? Mm. It may not be public charge, but there are other problems that might be associated with it. But if you're just paying the money and your kid is eating in the school, that's just like eating in a restaurant. I mean, a restaurant came there. There's nothing wrong with it.
Kavya from Facebook has an H-1B petition approved, then filed an amendment due to location change, and that currently has a request for evidence and wants to know if there'll be any issues with stamping if I'm traveling to my home country. So yes, you need to get the amendment approved in order to go for the stamping. If you go for the stamping based on the original petition or based on the pending amendment, you're likely to get a request, a 221G, administrative processing, putting everything on hold until the amendment can be approved, because the consulate needs to verify that you do have work available, and they can't do that based on the old petition approval. So the amendment needs to be approved.
The question comes from Srinivas from YouTube, is that, is it taking more than 90 days for EAD, even if you get the stamping from H4 stamping from the consulate? Yes, Srinivas, unfortunately, it's taking approximately 6 to 8 months to get the EAD approval, even if you get the H4 stamping from the consulate. Yes, that was a method previously people used to use it, but nowadays it's taking longer time to get the approval.
Meghna missed the biometrics appointment for her H4 that is filed with an EAD and had to reschedule and wants to know if she can still go for the litigation to get the EAD faster, even if the biometrics haven't been done yet. Yes, you can. Just know that if you still haven't done the biometrics by the time the government gets around to your case within that 60 days, they won't be able to approve it. So rather than waiting for them to send you a biometrics notice, you may want to consider just showing up at your local office and do a walk-in appointment for that. That would be a much faster option rather than waiting, because if you don't get it done within a certain period of time, there's a chance they may consider you abandoned the application.
Sam from YouTube has this question. He has his H-1B approved, visa has been stamped, but never came to USA on H-1B stamping. Now he got an L2. Can he come on an L2 visa, and then can he change using the previous H-1B, without going through the lottery system? Sam, the answer is yes, you can. You don't have to go through the lottery system again. There are two ways of counting in the lottery. One is you got a H-1B approval with the I-94, or you got the H-1B approval and it got stamped in the passport. You belong to the second category. So you are already counted towards the H-1B number. You don't have to be counted again. And the company that you're going to have the H-1B file doesn't have to be the same previous company. You can have the H-1B filed by any different company and you are not subject to cap.
Hanish from YouTube has a question for a friend who filed a transfer from company A to company B. Transfer got denied, refiled the transfer and got it approved this time, but only valid for 1 month. Wants to know if you can go back to the first company because that petition is still valid. So yes, you can, as long as the company A has not withdrawn the approved petition when you left, that petition remains valid until it expires. You can go back to that company without having to file a transfer, but you may need to consider traveling in order to clear up a potential status issue, because when the transfer got denied, that likely put the person out of status, and refiling and getting the approval, I'm not sure whether that approval was with the 994 or not, and whether it put the person back in status. So travel would be one way to clear that situation up.
Puneet has this question that his wife is an L1 visa, is completing her 5 years. She had the H-1B approved, and the stamping is not done though. I'm assuming that the H-1B is approved right now, or is it done previously? He didn't answer the question. Assuming that the H-1B is approved right now, with the same employer, you can convert that into change of status. She doesn't have to travel. But if it's been approved previously and she never got the stamping, as I explained to you previously, that if it's not stamped in the passport and it's not a valid I-94, it is not technically counted toward the H-1B. The other solution that I would say, Puneet, is that if your wife is pregnant and she is not in a stage where she could travel easily, you can actually apply for a B2 visa. Now, I do not suggest this for any other people, but if there is a medical things where people cannot travel when they're at advanced stages and the baby is very small, they can't travel, I would recommend that you convert your L1 visa into B2 visas and stay in this country until the kid is mature enough to travel.
Anil from YouTube has an interesting question. So I'm assuming considering marriage to a U.S. citizen and also has an H-1B and wants to know if they should wait 2 years and then file the green card application, or and stay on H-1B longer, or better to just file the green card application now.
Oh, very smart question. I would, I wouldn't say that, it's technically not legal. I'm not going to answer legally, but I'll tell you what I would do. I would file immediately, Emily, and get the green card, and then get the waiver. There's one other thing that you can do is that instead of waiting for 2 years, he can actually file the green card 6 months or 7 months from the time he gets married. Because they're taking about 18 months to get the green card. It's not when you applied the green card, it's when you get the green card. If by the time you get the green card and it's been more than 2 years, you could actually, so you can file 6 months or 8 months down the line, and by the time you get the green card, it's more than 2 years. Then you won't have any conditions attached to it.
Yeah, and I think that the other thing to consider is, yes, you might have a valid H-1B for some time, but you never know what happens in the future. There could be a job loss and you lose that status. So better to go with the green card where you can work anywhere and get that EAD rather than being tied to an employer on an H-1B. George from YouTube wanted to know, what is the filing fee for an LCA? So the LCA refers to the labor condition application, which is needed for an H-1B or an H-1B1 or an E3 type of visa. There is no filing fee for that. The labor certification application for a green card, the first step of the green card for perm, also there's no filing fee for that.
I have some objection to it, Emily. Does it mean that if we were to file in the new quota in 2020 April, don't we have to pay $10?
Well, yes. That is a proposed regulation right now, but it's not for the filing of the LCA. That is to be registered and entered into the lottery. They proposed a $10 fee for that. I expect that has to be paid by the employer. And they, as of right now, I guess they have it set up where you'll do it through pay.gov. They're looking into options for larger employers to be able to pay at one time for multiple people rather than doing $10 here and there over and over again. But it's not necessary for the LCA, it's just the lottery.
Deepak has this question. I'm a Canadian PR. Can you apply for TN visa? No, you cannot.
Tarun from YouTube, this is exactly what I was talking about earlier. H-1B is approved in consular processing. I'm on STEM OPT. I've not yet gone for visa stamping. My SEVIS became inactive today. Is there a glitch? What do I need to do? Yes, it is a glitch. And we've seen this happening. This is the third year now where we've seen this happening. I don't know why they can't seem to figure it out. If you have your H-1B approval requesting consular processing, you need to bring it to your DSO for your school so that they can request a data fix. They have to go into the SEVIS system and actually reactivate it with proof that your H-1B did not include a change of status, because it should not have been terminated.
Kapita from Canada has this interesting question, Emily, that what are the chances of getting green card and TN visa? Now here there are two things. There are a lot of timing calculations you need to do, Kavita. One timing calculation that you need to do is that, first thing is that, where are you born, Kavita? Are you born in Canada? Or are you born in India? If you're born in Canada, you belong to the Canadian green card line, not the Indian green card line. If you're born in India, even though you are a Canadian citizen, you are actually in the Indian line, which is a very long line. We already know that is, right? So if it's Canada, you're fine, you should be fine, you should be getting the green card within the 3-year span that you have on TN, but still you have some travel restrictions that you need to check with a lawyer. Now, if you are born in India, Kavita, and you got the Canadian citizenship, the length is too high, you practically cannot manage TN visa and get the green card through that. What is a better idea is probably to move from TN visa to H1 and then apply for the green card. That's the only way that I can think. Or just stay on TN visa forever. These are the only two options, because if you have a TN visa, you file an I-140 application, then extending TN visa is a tough job. You can't get a TN visa extension. That's going to become a problem. So that's the reason why you may have to move to H1 to apply for the green card.
I have two questions about H4 EAD litigation or any type of EAD litigation. The first is from YouTube. Jaya Raman wants to know if you're planning on filing the H1B, H4, and H4 EAD all together 2 months before it's going to expire. Does 2 months give you enough time for the litigation process? 2 months is a little short. Better would be 90 days, because you have to remember that, one, the EAD application has to be pending for 30 days before you can file the litigation. Once the litigation is filed, it can take up to 60 days to receive the EAD approval. So you need to plan for 90 days if at all possible. Second question regarding the litigation from Ekta on Facebook. Are there any repercussions for people that are filing litigation? And the answer to that is no. It is your legal right to do that. You can seek assistance from the court anytime the Immigration Service or any government agency is failing to do its job in a reasonable period of time. No one has seen any repercussions from filing. They've received their EAD approvals, and no repercussions are expected.
Harish has this question. It's more personal question, seems to be that. Is it worth waiting for the green card, or is it worth taking the Canadian PR? Harish, I can answer you this question. If I were you, based on the knowledge that I have about the business immigration in United States, and coming from a background where probably your background might match my background, I would go for Canadian green card option anytime, rather than waiting here for such a long period of time. I know the struggles. I don't have any other ways. There is no secret way. There is no shortcut for me to get you the green card. I know that. I know that. So I would go for Canadian green card if I were you.
Pallavi from YouTube has a question about when am I eligible for my employer to start the green card process? Do I need to have a certain position or a certain salary in order to qualify? So the green card process based on employment, first, the position that you're being offered does have to meet one of the categories. So typically that's going to be the EB2 or the EB3 category. So the position that you're being sponsored for EB2, the position itself must require either a master's degree or a bachelor's degree plus 5 years of progressive experience. So if your position is one that the education and experience requirements are lower than that, the position won't qualify for EB2. Then you look at EB3 as an option, and that is for a professional position, which is one requiring a bachelor's degree, or a skilled worker position, which is a position that requires 2 years of experience, education, or training. So if your position meets any of those, that's step one. And then as far as the salary requirements, that's going to be determined by the Department of Labor at the very beginning of the process. So once your employer decides they're going to sponsor you and what position you're going to be sponsored for, the first thing they typically do is submit a prevailing wage request to the Department of Labor. That spells out, this is the job we want to sponsor someone for, this is the title, these are the job duties, this is the work location, this is the education and experience required for the job. The Labor Department will then come back and say the minimum salary that can be offered for that job is X amount. And if your employer is willing to pay you that or higher, then they can move forward with the process. Now, does your salary have to be that amount already for you to move forward with the process? Not necessarily, but if your salary is below that, it could cause you issues later when you get to the I-140 stage.
Lalita has this question on the I-140. His I-140 is approved in June 2019. How long he has to wait before changing the jobs in the same company? He's an H-1B right now. You don't have to wait for a 6 months period, the 180-day period. The 180-day period is only if you're leaving the job or if your existing company is going to withdraw the I-140. If you're changing the job within the same company and your next job that you're going to be joining is a natural progression in your job, you don't have to worry about anything at all. You could do it. What is a natural progression? Yeah, if you move from software developer to the manager, that's fine. But if you move to a software developer to a CEO of the company within like 1 month or 2 months, and that doesn't look to be a natural progression to me. So if it's a natural progression, I don't have any problem. Ragini has this question that the I-140 has been approved with employer A. What if my spouse and the I-140, the EAD has been approved for the spouse based on the I-140 with company A. Now she wants to move to company B. What will happen to the EAD approval? Is it still valid for the spouse? Absolutely, it's valid until the expiration of the EAD. Absolutely no problem. I would strongly recommend that you wait after the I-140 has been approved for more than 180 days, which I'm thinking you already covered that base. But as far as the EAD is concerned, though, it has nothing to do with anything. It is still valid when you move from company A to company B. The spouse EAD is still valid.
Usha from Facebook has a bachelor's degree in commerce, and her employer is considering filing an H-1B petition on her behalf for an accountant position. The issue to be aware of, if this is a 3-year Bachelor of Commerce degree, which is common in India, that is not considered to be the equivalent of a U.S. bachelor's degree. So that by itself would not be enough to qualify for an H-1B. If you have that 3-year degree plus several years of experience as an accountant or in an accounting role, you may be able to get what we call an education plus experience evaluation that says you have the equivalent of a bachelor's degree in accounting. That might then qualify you for an H-1B for an accountant position.
What are the chances for Senate 983 passing Conrad 30 program? Well, this is a extension, Sagar, of the Conrad 20, which already exists there. At this point of time, we are noticing that a lot of these things are getting blocked out in the Senate because Senator Durbin thinks so that there should be a permanent solution for it, which he sponsored a bill about 4 or 5 years ago, 6 years ago, I'm assuming, and he wants that bill to be reintroduced and passed. But that bill, this Senate is not going to pass, and this president is not going to sign. So he's putting an objection. So all these bills, the immigration bills that would take the discrimination off and give more preference to the employment-based, at this point of time seems to have less chances of passing. But I would still, like you to put your effort on it, though. But I would not want you to count on these bills for your life so that you can plan your life accordingly.
Ramesh from YouTube says that his recent I-94 was not updated online, and he wants to know if he can still go ahead with an H-1B transfer. So I think it depends on what exactly you mean by recent I-94 is not updated online. I think what a lot of people are not aware of is that when you get an approval from USCIS that has a new I-94 on it, it does not get updated online. So if you have that approval notice and you go to the CBP website is still only going to show you the I-94 you got when you entered. The only time you get the new I-94 on that website is when you travel. So if you have the I-94 from USCIS on an approval notice, no problem filing a transfer there, regardless of what it says on the CBP website. Now, if you actually did travel and when you came back in, that entry is not appearing on the CBP website, you may want to consider going to the Deferred Inspection Office of CBP to get that cleared up before filing the transfer, because it's possible if you file the transfer, you might end up with the wrong I-94 number on the approval notice, and that can create a mismatch for driver's license renewal, Social Security issues, so better to get that cleared up ahead of time.
Ajit has this question. He has some credit card debts. Will that be a public charge? No, that's not a public charge. Credit card company is not the government.
Let's see, another question from YouTube. If someone's H-1B is hitting the 6-year limit, can they switch to H4 visa while waiting for the perm to be processed? Yes, I would. We've done that in the past.
Many times.
I would recommend that when you're doing that, at least don't hit the 6-year limit, at least leave a couple of days just in case people calculate things differently, but no issues doing that at all.
And a lot of people also are in the misconception that if they're on the H4 EAD, they can't file the green card application. You can file the labor and I-140 application on the H4 EAD, and you can resurrect your H-1B. So for example, if you're on H-1B, you move to the H4 EAD, you can apply the labor and green card application. Once the I-140 is approved, you can resurrect your old H-1B without subject to cap. There is no rule that says that you cannot apply for the green card while you're on the H4 EAD. There are many times we did it, absolutely no problem. Anything else, Emily?
I think that's about it for today.
And thank you for tuning in, guys. We covered as much as we can, but if we can't, Radio Newman PC does have a daily conference call, and you can check our daily conference call at rnlawgroup.com. Please don't forget to subscribe to the RN Law Group news section. Emily has a good blog, and she updates our immigration. Anything that's related to the immigration will come on Immigration Girl. She will does it in a way that you guys need to understand it, rather than what the law says, just what it affects you. She immediately puts on immigrationgirl.com. Don't forget to subscribe to immigrationgirl.com.
All right, thanks for joining. We'll see you next week.
Thank you, guys.